guys. Nobody is here. I don't know why. No. Oh, somebody's here. Who is here? I got a notification that I'm live on my own channel. Wow. One person is here besides me. No, Judy, you're not a nobody. Yay, my Judy's here. Okay, Judy, your job. You know how when Ian gets stuck on the 88? Excuse me. I ate too fast. Sorry. You know how on Friday Night Frenzy when Ian gets on the ADHD train and Rob steers him back? That is your job. Because we have too many documents for me to get off on a tangent. And I don't think we're going to get through all of them. I don't think it's possible. I don't read that fast. So we might still be doing this on Monday. Unless it just is super boring, then we'll just forget it. Oh, goodness. You guys can't see that. Can you read that? Okay, that's better. Now we can read it. Okay, this is. They're numbered. Okay. This one, I learned a new legal term. They call demonstrative exhibits chalk. I didn't know that. I had to look that up because I was like, what is chalk? Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to present the attached demonstrative exhibit or chalk to the jury. This chalk is necessary to clarify critical evidence and will aid the jury in understanding the testimony presented. Factual background. Miss Reed is accused of the following crimes arising out of the death of Officer John O'Keefe, murder in the second degree, and violation, blah, blah, blah. Manslaughter while under the influence of alcohol and violation of, and leaving the scene of personal injury and death in violation of. On January 29th, 2022, Mr. O'Keefe is captured on video surveillance footage leaving Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time he arrived at 34 Fairview Road and was broken in the early morning of January 29th, 2022, outside the Albert residence after being struck by the taillight of Miss Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview Road and the rear bumper of Miss Reed's vehicle. The source of the glass recovered from the bumper of Miss Reed's vehicle and the lawn of 34 Fairview Road is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist at the Massachusetts State Police Crime Lab, testified for the Commonwealth about the pieces of glass recovered from the crime scene and from the bumper of Miss Reed's vehicle, 26 RT at 97. What does that mean? This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Miss Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview Road and the bumper of Miss Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning that they were originally a part of the same object. Oh, this? Okay. Well, I'll read it once here, and then if it's in others, I'll skip it in others. Miss Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. During trial, Miss Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning one page containing representations of all recovered pieces of glass and graphics depicting which pieces came from which source of glass. The proposed chalk tracks directly with Miss Hanley's testimony and report. Oh, okay. The basic facts, not the glass stuff. I got confused about the glass. I know the ARCA guys made the cannon. I never thought about the glass hitting the taillight until the ARCA guys made the cannon. Because I was confused about why it was even necessary to talk about the glass he took from the bar. So I think this is a good idea. I didn't realize that they had to ask to be allowed to use demonstratives. I just thought if they wanted to use them, they could. So I guess every time they want to use a demonstrative, they have to make a motion and ask the judge's permission. Oh, I also wanted to start out by saying, I forgot, but I wanted to start off by saying, I am not a lawyer. So if there's anything that I don't understand, I apologize. And I will try to Google. If I can't Google and find it, I can maybe ask somebody, or maybe we can watch. I've been trying to watch like Peter Tragos and other people that are doing these docs to try to figure out stuff I don't understand. So I will try to, if there's anything that comes up that I can't figure out on the spot, I will try to find out from other sources, and then I should probably get out a notebook so I can write down any questions that I might have that I need to research. So, notebook. Hey, Terry. Uh-oh. Whoops, I hit full screen accidentally. Got to see my chat. Okay. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of pieces is called an item. These items are 1, item 3, the base of the cup recovered from the scene. 2, item 3, 5 pieces of glass taken from the bumper of Miss Reed's car, viewed by the laboratory as one item. 3, items 7 through 12, 9 pieces of glass taken from scene by Trooper Buchanan, viewed by the laboratory as one item. And 4, items 7 through 14, a single, or 7, 14, whatever. I don't know how they're labeling these. A single piece of glass taken from the scene by Trooper Proctor. Each smaller piece of glass within items 3, and 7, 12 has an additional lettered label referencing the individual piece itself within the broader item. Yeah, this is clear as mud. Yeah, they need a demonstrative. Item 3 contains the sublabels A, B, C, D, and E, each letter representing an individual piece of glass. These sublabels are the same as those assigned by Ms. Hanley in her testimony and in her lab report. Similarly, the 9 pieces of glass in item 7, 12 are labeled A, B, C, D, E, F, then I, K, L. Is that 7 through 12 or 7? I'm so confused. A, B, C, D, E, F, I, K, L. 7, 8, 9, 10, 11, 12. Nope. No, that's not. I'm confused. Skipping letters G and H, as was done in Miss Hanley's testimony and in her report. For each individual piece of glass. The chart includes a graphic next to the corresponding label based on which other pieces of glass that piece matched. Right. That's what, when I looked up chalk, that's what it said. That demonstratives aren't evidence. They're just to help the jury understand better. I guess that's why they call it chalk, because chalk is not like permanent. So they're just, I don't know. So it's not 7 through 12, it's 7-12. Like 7-12 is, I don't know. I never did get good at reading these. That's the one thing. Like, I can understand what's going on in court, but when it comes to reading these, I'm lost. That's why I said, if I don't know something, I'll try to find it out. But the graphics in the columns next to each label corresponds directly with Miss Hanley's testimony, particularly the testimony on pages 75 and 76 and 90 through 92 of the June 5th, 2024 trial transcript. Each sublabel has a graphic next to it indicating which other pieces of glass it matches. Through these graphics, the chalk summarizes Miss Hanley's conclusions into a simple chart, which Miss Hanley confirmed was an accurate representation of her testimony. Argument. To assist the jury in visualizing Miss Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit or chalk to aid the jury, which is attached hereto as Exhibit A. The demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but is not evidence itself. Demonstrative exhibits can take many forms, including live demonstrations, charts, and even literal chalk figures on a blackboard. Oh, maybe that's how it got its name. Demonstratives are particularly, the judge knows what a demonstrative, do they have to put this in the motion? Demonstratives are particularly useful where a party presents complicated testimony that may be difficult for a jury to understand or visualize. Allowing the use of a 34-page bar chart as a chalk to depict hours defendant billed to Medicaid for a particular period. Well, that's going to be a big demonstrative. Jeez. These sorts of aids are appropriate here. 1, they are relevant. 2, they are not more prejudicial than probative. And 3, they sufficiently resemble the actual event so as to be fair and informative, or they are a fair representation of the facts the chalk aims to clarify. So if they're not evidence, they don't go back with the jury then, right? So they just have to look at them and remember them. I mean, I guess that would be enough if it helps you to understand. The court has broad discretion in determining whether to admit a demonstrative aid. I. The proposed chalk is highly relevant. Is that I or 1? I don't know. Miss Hanley's testimony is clearly relevant, i.e., whether any of the glass on the bumper matches the cocktail glass at the scene, or is from some different unidentified source, and goes directly to whether the evidence in this case supports that Miss Reed struck John O'Keefe or the cocktail glass in question. The relation hang on a minute, guys. My nose was itching. They I don't remember. Do they have the glass? Oh well, I guess they do have the glass pieces from the actual cocktail glass or whatever kind of glass it was. They called it a cocktail glass, yeah, but it looked like wasn't it like a taller glass? Didn't look like a cocktail. What I would call a cocktail glass. Okay, I lost my place, but my nose was itching. I had to. Sorry. Okay, let's see. And it goes directly to whether the evidence in this case supports that Miss Reed struck John O'Keefe or the cocktail glass in question. The relationships between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Miss Hanley's testimony about this glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all the other pieces in order to make sense of Ms. Hanley's testimony. The complexity of this testimony is underscored by Ms. Hanley's frequent references to her notes and requests for counsel to repeat questions, particularly questions about the relationships between those pieces of glass. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that testimony is accurate. However, if a lab expert has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant but essential. 2. The chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. This chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Miss Hanley's testimony, which would otherwise require jurors to memorize and differentiate the titles and source of various pieces of glass with labels that closely resemble one another. It is merely a depiction of which glass pieces match others and a visual representation of Miss Hanley's live testimony. Given that the chalk corresponds so closely with Miss Hanley's testimony, a witness for the Commonwealth, it is difficult to see how the chalk could be remotely prejudicial, not presidential, prejudicial. Wait, this is a defense motion? Hold up. Yeah, this is a defense motion. This woman is a. But did that say she was a witness for the Commonwealth? It does. Given the chalk corresponds so closely with Miss Hanley's testimony, a witness for the Commonwealth, it is difficult to see how the chalk could be remotely prejudicial. Okay. Even if the court finds that there is some prejudicial tendency by the proposed chalk, it is far outweighed by probative value. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations in chalk, even where there is potential for extreme prejudice. In Commonwealth v. McGee, where the defendant was accused of murdering his partner in front of their 6-year-old child, the Supreme Judicial Court of Massachusetts upheld the allowance of a physical demonstration by that child, then 10 years old, of the position in which he saw his mother on the couch when she was killed. In support of this decision, the court highlighted that testimony about the decedent's position on couch at the time of a murder was crucial in determining whether the premeditation element of murder in the first degree was met. Given that a live demonstration by a child of the position his mother was in when she was killed was permitted as more probative than prejudicial, this proposed chalk, which simply depicts Miss Haney's testimony, is certainly more probative than prejudicial, if prejudicial at all. 3. The proposed chalk directly mirrors Miss Hanley's testimony fairly and accurately. As described in detail above, and as seen in the chalk itself, the chalk is merely a summary of Ms. Hanley's testimony. The 4 categories displayed in the chalk, the labels used in the chalk, and the connections between each piece of glass are all drawn directly from Miss Hanley's testimony. In fact, during the first trial, Miss Hanley was shown this exact chalk, which she confirmed on the record was an accurate reflection of her testimony. Conclusion. Without the chalk, Miss Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Miss Hanley will present. Given the great relevance of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Miss Hanley's testimony, the proposed chalk should be permitted. For the above reasons, Ms. Reed respectfully requests that this honorable court allow the attached chalk to be presented to the jury. I don't know enough about law to know if that's a thing or not. Can we see the chart? Is it attached on this? Nope. Because this is a witness for the Commonwealth, but the defense is asking for a demonstrative for their witness. I don't know if that's odd or not. One document that I want to talk about, I'm not going to read because it's just a list of witnesses, but I was talking to Judy about this yesterday. So she sends me the Commonwealth's list of witnesses, and I see, I guess, because she's the Commonwealth's witness, but the defense is the one asking for the demonstrative. So I guess the defense wants to use the demonstrative when they cross her. Now, your uneducated guess on the next one I'm going to talk about. Like I said, I'm not going to read it because all it is, it's a witness list. A witness list from the Commonwealth. And as soon as I saw it, I texted Judy back and I was like, he's calling Turtle Boy. For what? Why would Brennan call Turtle Boy? What value is Turtle Boy's testimony? None. He wasn't there that night. He doesn't know anything about what happened. And he has been, what's the word? He hasn't been convicted yet. He's been accused of witness tampering or intimidation or whatever. In the last trial, he wasn't allowed in the courtroom for certain witnesses because he had been accused of witness intimidation for certain witnesses. So he wasn't allowed to be in the courtroom while they were there. So I texted Judy and I was like, for what? Why is he calling Turtle Boy? And Judy said, because that keeps him out of the courtroom, because witnesses are sequestered. Yeah. So Travis and I are having dinner last night and I told him about it and I was like, but that doesn't stop him from live streaming it. And then I went, oh crap, yes it does. He can't watch it. He can't live stream it. He can't even watch it. He can't watch it to even report on it. He can't do anything. That means he stays in the dark the entire trial. He's not allowed to know anything about it at all. He can't look at X. He can't look at Facebook. He can't look on YouTube. Nothing about the trial. Nothing. Brennan is, I'm sorry, that man is an ass. And you guys know I don't like to cuss, but that man is an ass. I didn't even think about why he called him, and then Judy was like, to keep him out of the courtroom, and I was like, oh well, that's okay. He'll just watch it on YouTube. And then I realized, it dawned on me, that man is going to have a conniption because he can't watch the second trial now. He is going to have a heart attack, an aneurysm, something. He's going to go insane. He's not going to be able to help. He's not going to be able to contain himself. He's going to go BSC. He really, really is. Mark Betterow better buckle up, because he's probably going to have a whole new court case. Yeah, that's what I'm saying. Mark Betterow, buckle up, because you're fixing to go back to court. Absolutely. I cannot believe Hank Brennan did that. Ugh. Yeah. And his is stinkier than most. Absolutely. Oh my God. I cannot believe that man did that. I cannot believe he did that. Why? What threat is Aiden Carney? What threat is he? None. Absolutely none. He knows the truth. That's the threat. He knows the truth. Oh, this one looks good. I doubt this one's going to get denied. I have a feeling anything that was allowed in the first trial is going to be allowed in this one. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. Now, I've said it before and I will say it again. I don't think a stupid fight in Aruba a month before has any bearing whatsoever. I'm sorry. I ate really fast and now I'm drinking Pepsi, so I'm burpy. I'm gassy. I'm sorry. A stupid argument a month before in Aruba. I don't think that has anything to do with what happened that night. Yeah, they got in an argument. She's insecure and he has 2 kids and a very important job, and she has issues. Okay, so yes, toxic in that she doesn't know how to deal with he seems to have a better handle on his priorities than she does. That's just my opinion from what I know, what little I know about them as people. He just seems more solid and secure of a person than her. I could be totally wrong, but that's kind of what I got. Hey, madam, I am feeling much better today. Lemonade, yes, motions and lemonade. Are you talking about Chris Albert? Who's okay? I've forgotten who Helena Rafferty is. Who's your future ex boyfriend? AJ? He's married. You can't have him. He's taken already. Tell me again who Helena Rafferty is. I've forgotten her. Yeah. Yeah, AJ's married. How come? Wait a minute. I don't know about her. Why don't I know about her? Why don't I know about her? Was she mentioned in the first trial? How come I don't know about her? Wait. Oh, yes, definitely. Definitely. Absolutely. Oh, okay. Why? Yeah, there were some names on there I didn't recognize, and I thought maybe I just forgot them from the first trial. Maybe they're because they were new and I didn't know them. Why in the world? Yeah, and the Aruba, the sisters from Aruba are on the witness list again too. Oh, that video that still pisses me off. I mean, at the time, I was like, "There's your smoking gun right there. There's proof that they're covering it up," because um, Lally didn't and Buchanan they were just talking about it like no big deal, and we were like, the four on the doors backwards, police on the police cars backwards. That video is backwards. We totally noticed it. And then they weren't saying anything about it. And I was like, we were like, why are they not saying the videos backwards? What is going on? And then Alan Jackson got up there and Yuri's like, oh yeah, it's backwards. We're like, what the heck is that? And and then commentators and attorneys and stuff after that day put out videos, recap videos and stuff that night, and they were all like, yeah, the video was backwards. And I was like, that's crazy. That is absolutely crazy. There should be something done about that. And then nothing was done, of course, because Bev is biased. And now, asking for for dismissal and everything. And no, everybody is still just ignoring the video. It's insane. It is just so insane. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. Now comes the defendant, Karen Reed, and respectfully moves this honorable court. She's not honorable. Honorable court in limine to exclude any references to the irrelevant, inadmissible, and prejudicial events. Oh, because it's just for the events that happened in Aruba on December 31st. So it won't apply to Chris Albert. It's just to the Aruba stuff. And prejudicial events that purportedly transpired in Aruba on December 31st, 2021. As grounds for this motion, the defendant states that the proffered evidence is not relevant to any material issue in this case. Yeah, I know. She's a horrible, I don't know, maybe she's not a horrible person in general. But she shouldn't be the judge on this case, that's for sure. And if Peter Tragos says somebody's biased, they're biased. Because that's okay. It's a lot. I'm surprised you read them all. I'm surprised you didn't just send them to me and be like, okay, I did my job. I'm surprised you read any of them. I've not read them. This is my first time reading them. As grounds for this motion, the defendant states that the proffered evidence is not relevant to any material issue in this case. Should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by the substantial risk of unfair prejudice to Miss Reed. Maiko! Factual background. Ms. Reed is accused of the following crimes. Oh, okay, so this stuff is all, we know what she's accused of. This is all the same stuff. The defense suspects that the Commonwealth will again seek to, they know they will because they've seen the witness list. The defense suspects that the Commonwealth will again seek to admit testimony regarding a completely irrelevant verbal argument between Miss Reed and a woman named Marietta Sullivan, which occurred in Aruba on December 31st, 2021, for the sole purpose of trying to assassinate Miss Reed's character in the eyes of the jury. At Miss Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Miss Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28, 2022. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior between Miss Reed and a third party, which had no logical relationship to the crimes charged. Judy, are you still doing that? You need to go to the doctor. You need to at least go get some Zofran. Go to the doctor to get some Zofran. Because you need to stop puking. You're going to get dehydrated. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month later on January 29, 2022, or that this remote and isolated incident was even a point of contention in Miss Reed and Mr. O'Keefe's relationship after that trip. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammatory incident in which Ms. Reed apparently got angry at another woman, not the decedent, because she reportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad acts and character evidence for no reason other than to sully Miss Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's words, an asshole. At trial, Laura Sullivan admitted that she was not present during this verbal exchange between Marietta Sullivan and Miss Reed. So her testimony about the December 31st, 2022 incident in Aruba is almost entirely comprised of inadmissible hearsay. Despite the court's limiting instructions about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Miss Reed crazy and that he had insinuated he was unhappy in the relationship. He didn't leave. He was still there a month later. Marietta Sullivan's trial testimony was also extremely prejudicial to Miss Reed. Her retelling of the verbal dispute with Miss Reed was not probative of any material fact or element in the case, and it culminated with Marietta telling the jury decidedly that Miss Reed sucks. As set forth herein, this evidence must be excluded. Argument 1. The Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted in evidence. And in granting such a motion, a judge has discretion similar to that which she has when deciding whether to admit or exclude evidence. Spike Aunt Judy loves you. It is fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indictably or not, for the purpose of showing his bad character or propensity to commit the crime charged. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to kill the victim, such evidence should not be admitted if it relates to events which occurred at a time too remote for the killing. Animosity between husband and wife 3 years before murder too distant to be probative of husband's motive, and evidence of defendant's husband's adulterous relationship which terminated 7 months before wife's death not probative of motive to murder. Temporal remoteness is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charged. Here, there is no such logical relationship. In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to kill the victim, the evidence must actually establish a prior hostile and violent relationship between the victim and the defendant. Prior acts evidence included police testimony about a domestic dispute requiring law enforcement response and witness testimony about multiple physical disputes. Requiring law enforcement response and witness testimony about multiple physical disputes between defendant and victim in order to show the nature of the relationship. So that was in the Commonwealth v. Darling Wayne case. That was police testimony that it's of prior instances, and there was nothing like that in this case. It was just a verbal altercation when they were on vacation. And in Commonwealth v. Rentala, the evidence included defendant's prior arrest for domestic violence, multiple restraining orders, and pending divorce proceedings. And there's nothing like this in their case. Commonwealth v. Orberly, evidence including extreme physical violence, multiple emergency room treats, and threats to kill. So all that kind of stuff could be admitted, but in this case, that's absolutely none of that. This case law is not comparable to this incident, during which Miss Reed briefly became angry with another woman, not the decedent, because she believed that Mr. O'Keefe had kissed that woman. There was zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Miss Reed or Mr. O'Keefe's relationship. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. Here, testimony by Marietta Sullivan that Miss Reed became angry with Marietta, not the decedent, on December 31st, 2021, because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Miss Reed had an intent to murder John O'Keefe on January 29, 2022. This event was remote in time and was clearly not an issue between O'Keefe and Miss Reed on the night in question, as evidenced by video surveillance footage from the Waterfall Bar and Grill on the night in question and the testimony of 8 witnesses, all of whom agreed that the couple appeared happy and in good spirits. There is no logical relationship between the Aruba incident and the crime charge. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Miss Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. The sole purpose of the Commonwealth's attempts to admit this evidence is to sully Miss Reed's character by allowing Marietta Sullivan to testify that Miss Reed sucks. If we are to believe the Commonwealth's best evidence that Miss Reed said "go fuck yourself" to Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba, that evidence is simply not probative of a motive to murder Mr. O'Keefe more than a month later when the parties were, by all accounts, in good spirits. In order for there to be a logical relationship between the prior bad acts evidence and the crime charged as required by Commonwealth v. Pino, the jury would need to believe that Miss Reed reacted with a verbal "go fuck yourself" when she believed she observed adulterous behavior on December 31st, 2021, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any arguments on the night in question. That type of reasoning defies logic. Miss Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Miss Reed's character and prejudice the jury against her. Miss Reed reasserts here that this evidence has no probative value regarding the crimes for which she had been indicted. However, even if the court finds that this evidence is relevant, any marginal relevance of Miss Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have in terms of evidencing a hostile relationship or intent to murder is far outweighed by the prejudicial inflammatory effect it will have on the jury. Who holds a grudge? Karen? I think she does. I think she does because I think the flirting with Brian Higgins, I think all that was about holding a grudge because she steered him to where their surveillance cameras. Oh, are you talking about the girl that she said go F yourself too. Yeah, she holds a grudge too. But I think Karen does too. I think all that I think all of that flirting with Brian Higgins and then steering him in front of the security cameras in the house, I think that was Karen holding a grudge. It was either Karen holding a grudge or Karen wanting him to see it so that he would like be jealous and say, "Oh, I need to pay more attention to her because I'm going to lose her." You know, that kind of thing. I think Karen was just really insecure. That's what I think. I think she wanted him to be clingier, I guess. And I think that's why she did that with Brian Higgins. I don't think she really wanted to be with Brian Higgins. I think she wanted to use that to make John like more attentive or whatever. And I think when people are insecure, they feel like they should get more attention from their significant other. But I think that's when you have a real relationship, a good relationship with somebody, you don't need that. You shouldn't have to have that all the time. And I think that's what was wrong in their relationship. I don't necessarily think it was either one's fault. I think they just weren't a good fit for each other. And I mean, I don't think she killed him. I just think that was why they argued all the time. And then because they argued all the time, she made the perfect scapegoat for whatever happened. And of course that's just my opinion, but yeah, that chick in Aruba, yeah, she holds a grudge. Absolutely. Because, you know, I can understand Karen being mad, but I would, if it was me, if I was that type of person, you know, I've said many times when I've talked about this, if it was Travis, I would have just walked up to her and said, "Oh, hi, I'm Debbie. You know, who are you?" I wouldn't have yelled, "Who the F are you?" across a hotel lobby. I wouldn't have done that. I would have just gone up and said, "Oh, hi, I'm Travis's wife. I'm Debbie." You know, um, so I don't. That just not me. But I can understand being upset. But I would have been upset at him, not her. I would have been like, "What the heck are you doing? Who is this woman? Why were you hugging her? Why, you know?" But see, I wouldn't have blown up. I would have just inserted myself into the situation and been like, "Hi." That's the way I do things. 2. The Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Moreover, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. The Commonwealth's argument in prior proceedings that this testimony is admissible in order to show the defendant's state of mind is misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there is no evidence to suggest that Miss Reed was still upset about it on the night of January 28, 2022. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than inadmissible hearsay and prejudicial character evidence. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness in Aruba on December 31st, 2021. Involving Miss Reed, Mr. O'Keefe, and her sister, Marietta Sullivan. Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip, i.e., that Karen told her she needed her own bathroom and that she didn't want to share a room with John's kids. The Commonwealth then elicited additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is crazy during a later conversation on the night of December 31st, 2021, and that on January 2nd, 2022, John insinuated that he was unhappy in their relationship. Notably, Massachusetts courts have long held that the admission of hearsay statements, I know, right? So demanding. She's so demanding. You know what? If people really understood why she wanted her own bathroom, they would say, "Oh, yes. Oh, yes, we will give you your own bathroom." People don't get it. People do not get it. I'm a nurse. Trust me, I get it. I know you want her to have her own bathroom. Notably, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relation, and two, it's New Year's Eve. You're with your boyfriend. You don't want to share a room with kids. They were old enough that they could be in a room by themselves, and then you could have an adjoining room and have a good time. I mean, come on. Come on. Notably, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. Thus, all of Laura Sullivan's testimony regarding the Aruba trip constitutes prejudicial and inadmissible hearsay, which must be excluded. Dang, my nose is itching again. Note, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Not only is this inadmissible hearsay, but it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation. Oh, man. My nose is itching again. I don't, I don't remember. Was that, man, did they object to that? I don't remember. I thought he actually said that. I'm not going to go back through hours of trial to try to find that. I believe it though, if they say it, but I'm sure they must have objected. I don't know why my nose keeps itching. Ugh, dang. Probably pollen. Is this time of year. For the above reasons, Ms. Reed respectfully requests that this honorable court exclude any reference to the December 31st, 2021 incident in Aruba. He keeps saying honorable. I know he has to, but yeah, whatever. Sure. Okay. What? I'm not sure what this one is. I don't know why these are numbered the way they are. It goes from. Oh, no, it doesn't. Never mind. I thought it jumped from 560 to 565, but it doesn't. Never mind. Defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. I might just have to keep the camera off. I don't know what my nose is doing. You guys don't want to watch me scratch my nose. I don't know how I'm going to read and scratch my nose at the same time, though. Dang. Does it mean something if your nose itches? If your ears itch, it means somebody's talking about you, right? Or is that your nose? Isn't there some folklore thing about if your nose itches? Now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding portions of defense motion in limine to exclude certain witnesses before and after testimony, namely the portion of the motion referencing text messages that are subject to a protective order issued in connection with this case, and Exhibit A containing a copy of those text messages. Good cause exists for the impoundment Okay. Oh, now I made your nose itch? Okay. Yay, everybody's going to have itchy noses now. Okay. Impound makes me think of car, getting your car impounded. Okay. This is confusing me. Now comes the defendant, respectfully moves an order to seal portions of the defendant's motion to exclude certain witnesses before and after testimony, namely the portion of the motion referencing text messages that are subject to a protective order issued in connection with this case, and Exhibit A containing a copy of those text messages. Good cause exists for the seal of this information because it is subject to a protective order. In support of this request, Ms. Reed hereby submits 2 copies of defendant's motion, an unredacted copy of defendant's motion for the court file, and a copy of motion with all reference to and copies of the text messages that are subject to a protective order, redacted such as they are not visible to the public. So what text messages are they talking about? So they're just, I'm confused. So they're sealed just before the trial, before and after the trial, but they're going to be talked about during the trial? That's nice and confusing. Okay, now it was 560. Okay, that one is just Elizabeth Little's affidavit about sealing the text messages. We don't need to read that one. This is defendant's motion to exclude witnesses. Now comes the defendant, Karen Reed, and respectfully moves, exclude certain witnesses from the courtroom before and after testimony in this trial. Rule 21, sequestrate. How do you say that word? Sequestration of witnesses. I don't know if he has to do it or if he's doing it to butter her up or what. Rule 21 of the Massachusetts Rules of Criminal Procedure states that upon his own motion or the motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. The power of a judge to control the progress and within the limits of the adversary system, the shape of a trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Man, it would suck to be a lawyer. You have to put all, I wonder if they have, like, these forms are already filled out because everybody knows about sequestering witnesses. See, when I didn't think about it, I said it perfectly. Sequestering. Now watch, next time I have to read it, I'll screw it up again. Ms. Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. And they need to, because they were there after trial. They were there during closing statements. It was creepy. They were staring at her. As this court likely recalls, after they testified, members of the Albert, I wonder how hard it was for him to not write the McAlberts there. As this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family facing the jury sporadically throughout the remainder of the trial, including closing arguments. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the Alberts and McCabe families were able to stare down the jury from their position in the courtroom. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe families, calling their presence in the courtroom small gallery facing the jury completely and utterly inappropriate. Noting that the Albert and McCabe families were substantial focal points of the trial, the juror noted how unbelievable it was that the families were allowed in to stare the jury down. Whoa, what was redacted from this? This was extraordinarily prejudicial to Miss Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during closing arguments directly facing the jury, which according to at least one juror was intimidating, purporting that an act need not be overtly threatening to be considered intimidating, defining the threshold of intimidation as what would instill fear in a reasonable person. As the jurors heard through testimony, the Albert and McCabe families have deep connections and familial ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Alberts staring the jury down. Give me the stink eye. Absolutely, Maiko. It intimidated me, and I wasn't even there. It was like, they shouldn't be there. They shouldn't be doing that. That's scary. Here, the judge has broad discretion to order the see, I told you. Sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one jury reported feeling intimidated by the presence of certain witnesses towards the end of the trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration. Why can't I say it when I read it, but I can say it when I'm not reading it? Sequestration order excluding Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Miss Reed. Conclusion. For the above reasons, Miss Reed respectfully requests that this honorable court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. And I agree, but I don't think she's going to do it. I do not trust Bev at all. Not at all. These are all defendants. Nice try, StreamYard. There's no audio, so you don't have to worry about dropping my audio right now. Hey, Jelly Bean. What? Some of this surprises me. I didn't realize how much they have to ask for. I thought motions in limine were... Sorry. Maybe I should quit drinking Pepsi because I keep burping. As I take another sip. I thought motions in limine were things that they wanted excluded. But this is something they want. And it kind of blows my mind. I thought some of these things they're asking for, I thought were automatic. Like the demonstratives. I thought they just did it. I didn't know they had to ask for permission. This is asking for permission to view. But I thought motions in limine were always stuff that they didn't want in. But I guess, I don't know. Like I said, I don't know what I'm doing. I'm not a real lawyer. I just pretend to be one on YouTube. Defendant's motion in limine for view. Now comes a defendant, Karen Reed, and respectfully moves this honorable court pursuant to whatever, to order that the jury be taken on a view of the alleged crime scene. And then he cites case law. The power to inform itself by a view is inherent in a court at common law. They went to view it last time, didn't they? I thought they did. Miss Reed specifically requests that the court order a view of 34 Fairview Road in Canton, Massachusetts, and 2, the exterior of the 2021 Lexus LX SUV, hereafter the vehicle. Miss Reed further requests that the vehicle be towed to the public roadway in front of 34 Fairview Road. I don't think they did that. I know. See that? I guess that's what I was thinking. Because as a nurse, there's all kinds of stuff that we don't have to ask for because they're standing orders. We just do it, and then the doctor will sign it later. Or we sign it, and then we sign the doctor's name, and then the doctor comes back later and signs it. Because they're standing orders. There's like a list that we're allowed to write. So I thought that law was kind of like that. Yeah, but the Lexus was there at 34 Fairview? Oh, okay. I didn't think they saw the Lexus at the site. I thought they saw them separately. This seems like a no-brainer. I don't think she'll deny this. Ms. Reed further requests that the vehicle be towed to the public roadway in front of 34 Fairview Road, Canton, Massachusetts. Finally, Ms. Reed requests that the Honorable Court permit Ms. Reed to attend the view, subject to any reasonable restrictions the court deems necessary. Whatever that case law notation is, provides that the court may order a view by a jury impaneled to try a criminal case. Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview Road and the vehicle at issue, the alleged murder weapon, would assist the jury in reaching a verdict. Allowing the impaneled jury to view the crime scene located at 34 Fairview Road will be particularly useful because the lawn appears to be much more expansive in photographs than it does in person. In addition, allowing jurors to visually inspect the vehicle will assist the jurors in assessing whether Mr. O'Keefe's injuries are consistent with having been struck by any portion of the vehicle. Commonwealth v. Curry. Chief purpose of a view is to enable the jury to understand better the testimony which has or may be introduced. Hey, Jenny. Although what is seen on the view may be used by the jury in reaching their verdict in a strict and narrow sense, a view may be thought not to be evidence. Properly speaking, no evidence should be taken or testimonial comments made during the taking of a view. During the view, the essential features of the crime scene may be pointed out by counsel, it being permissible merely to point out to the jury marks, matters, and things, but not to otherwise speak to the jury. As with the decision whether to hold a view, the decision to allow a defendant to be present is within the trial judge's discretion. Ms. Reed respectfully requests that the court allow her to be present for the view, subject to any reasonable restrictions the court deems necessary. For the above reasons, Ms. Reed respectfully requests that this honorable court allow this motion for review. And I think that's a good idea. I mean, I know they did it before, so she'll probably allow it again. But it's confusing because people are imagining her pulling up in the driveway. And she didn't. She pulled up in front of the house. The road in front of the house. And so, and if I remember correctly, if I understand it correctly, I should say, if I understand it, yes, again, Bill, I'm addicted to doing this now. It's my thing. I'm not streaming tomorrow. I'm resting tomorrow. My body has decided it has to rest at least one day. I don't have anything else to do. So you're just jealous because I have more stamina than you do. So if I understand correctly, she was parked on the road, like the house is here. She's parked on the road here facing that way. And the door's like over here. So she kind of is facing away from where he went into the house. So she kind of didn't have a good view. I don't know. I might not be understanding it correctly. But that's the way, that's kind of the way I thought she was parked, where she was like, it is fun. Yeah, it is. So I think people are under the misconception that she was pulled up in the driveway, sitting in the driveway looking at the door. And That's not. And it also, like in the pictures and stuff, in that digital thing they had in court, this yard looks huge, and it in real life it's not as big. So, and you know how everyone in the trial said they looked out the window and they didn't see him, but supposedly she hit him, but they didn't see his body on the yard, laying in the yard. They were looking right out the window and they saw her SUV, but they didn't see him laying in the yard. So I think it's good that they go out there and look. This one I don't understand. Because it says voir dire. Do they mean like when they're picking a jury voir dire? Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude testimony regarding expenses incurred by Miss Reed for expert voir dire. Given that these expert expenses were incurred based solely on the request of the Commonwealth and the mandate of the court, their inclusion in testimony would not be probative. Are they talking about voir dire whenever they get up there and they're doing the expert thing? You know, when they like do the part where they have to ask them about their CV and their background and all that stuff to qualify? Well, I know what voir dire means, but I mean, which part of voir dire are they talking about? Like when they get up there and ask them all this stuff about qualifying them as an expert? Is that what they mean by voir dire? I'm trying to understand what part of the trial they don't. In advance of both the first and second trial in this matter, the Commonwealth requested the court order in-person voir dire for defense expert witnesses. In advance of both the first and second trial in this matter, the Commonwealth requested and the court ordered in-person voir dire for defense expert witness, including Dr. Daniel Wolf, Dr. Andrew Rentschler, and Dr. Marie Russell. As a result, Ms. Reed had to expend significant resources to pay for out-of-state experts to travel to Norfolk Superior Court for voir dire hearings, which span multiple days. To the extent that the Commonwealth seeks to cross-examine these experts regarding any fees they have been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees expended to have the. Oh, okay. I get it. He doesn't want them to talk about the expenses for when they had to come for the Dauber hearings. Expenses incurred by Miss Reed as a result of expert voir dire are irrelevant. The fees and expenses related to expert voir dire are entirely irrelevant to expert credibility and do not make any fact of consequence more or less probable. Discussion of the fact that an expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias. Holding that while discussion of an expert standard fee is acceptable, suggesting that the expert is a hired gun is impermissible. However, testimony about fees and expenses incurred as a result of voir dire have no bearing on an expert's credibility at trial. This is particularly the case here, where in-person voir dire was conducted at the request of the Commonwealth and where a significant portion of voir dire expenses came from travel and lodging. Discussion of fees and expenses incurred by the defense for expert voir dire would not provide the jury with any additional clarity. Okay, we're not going to read that one. I get it. I get it. I think it went off the air. I like that show. That was a good show. Okay, let me find some more. Okay, so that was just because of the Dauber hearings or the voir dire of the experts and stuff. They had to pay them extra for that, and they don't want that to come up during trial. So that's stupid. It's not important to the trial stuff. Oh, and this one is about jury voir dire. Oh, I don't know. This one looks kind of interesting. See, there's another thing I didn't know that I thought you have to ask what questions you're allowed to ask during voir dire for your jury panel. Oh, I'm learning all kinds of stuff today. Now comes the defendant, Karen Reed. I'm tired of reading that. For attorney conducted panel voir dire of the jury veneer in order to determine whether such potential juror stands indifferent. Ms. Reed requests that defense counsel be permitted to conduct panel voir dire of the jury veneer on the following subjects: whether previous experience with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial. Oh, so the lawyers have to ask certain questions if they want them? Oh, that's interesting. See, that's the thing that we don't ever get to see is jury selection. I lost my place. Whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved in or have close family friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, whether prospective jurors have been the victim of any violent crimes, and whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. Ms. Reed reserves the right to ask reasonable follow-up questions to each prospective juror pursuant to Rule 63C of the Rules of the Superior Court. Part of the Sixth Amendment right to an impartial jury is an adequate, I've been saying it all day, voir dire to identify unqualified jurors. Prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts, and whether to permit attorney-conducted voir dire in any given case was entirely within the discretion of trial court judges. However, in an effort to better protect the right to an impartial jury and ultimately a fair trial, describing voir dire as a way to examine whether the juror related to either party or has an interest in the case or has expressed or formed an opinion or is sensible of any bias or prejudice, the Massachusetts legislature amended that law, recoded. Through that amendment, the legislature created a right to attorney-conducted voir dire. The current version of the statute, so amended, states that, in addition to whatever jury voir dire of the jury venire is conducted by the court shall permit, upon the request of any party's attorney or self-represented party, the party's attorney or self-represented party to conduct an oral examination of the prospective jurors at the discretion of the court. The trial judge shall allow attorney or party voir dire if properly and timely requested. The Massachusetts Supreme Judicial Court has interpreted this most recent version of the statute as creating a right to attorney-conducted voir dire, and accordingly has expressly stated that trial judges must permit attorney-conducted voir dire upon request. Did that say must? Must. I hope Bev reads that. Must. Not should. Must. Not could. Must. Accordingly, because this request for attorney-conducted voir dire was properly and timely made, the court is required to permit attorney-conducted voir dire. All questions proposed by defense counsel are consistent with the guidance in Superior Court Rule 6 and necessary to ensure Ms. Reed's Sixth Amendment right, and so should be allowed. While trial court judges must grant attorney-conducted voir dire when properly and timely requested, judges retain discretion over the scope of attorney-conducted voir dire. The court may impose reasonable limitations upon the questions and the time allowed during such examination, including but not limited to requiring pre-approval of the questions. Superior Court Rule 6, hereafter Rule 6, states that judges may permissibly use that discretion to place reasonable restrictions on the subject matter, time, and method of attorney or party voir dire of the rules of the Supreme Court, and precludes attorneys from asking a small number of questions on particular subjects. Though Rule 6 also includes guidance that judges should generally approve a reasonable number of questions intended to reach certain permissible ends or inquire into certain relevant topics of the rules of the Supreme Court. These questions include: seek factual information about the prospective jurors' backgrounds and experience pertinent to the issues expected to arise in the case, may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise in the case, inquire into the prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed, and are meant to elicit information on subjects that controlling authority has identified as preferred subjects of inquiry, even if not absolutely required. Rule 6 explicitly instructs that in doing so, judges should consider the goals outlined in Rule 6. which includes permitting parties and their attorneys to participate in the process of identifying potential juror biases. Rule 6 of the Rules of the Superior Court. The subjects that defense counsel has proposed for attorney conducted voir dire are subjects into which Rule 6 instructs inquiry should be allowed. Most of the proposed voir dire subjects will aid defense counsel in evaluating prospective jurors' abilities to be impartial by eliciting specific evidence of relevant biases and as bias in favor of police officers or against people who are accused of operating a motor vehicle under the influence of alcohol. Consequently, questions on these subjects should be allowed as questions that seek factual information about the prospective juror's background and experiences pertinent to the issues expected to arise in the case. Rules of the Superior Court. Rule 6. Sorry. I'm swallowing air and drinking Pepsi through a straw at the same time. Not a good combination. Rule 63C1 of the Rules of the Superior Court and may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise in the case. Rule 63C2 of the Rules of the Superior Court. Discussing the value of and the value of encouraging questioning sensitive to the possibility that bias may arise out of a family relationship with law enforcement, even though a familial tie to law enforcement is not dispositive of bias. That was like my jury duty when my dad was the boss of the trooper, the arresting trooper. I stood up and I was like, nope. It was a drunk driving case. And my dad was the boss of the arresting officer. No way in hell. There's no way in hell. Like, no. I can't be on this jury. I'm sorry. In view of the violent nature of the charge of murder, it would have been preferable had the judge asked the veneer collectively whether any of the prospective jurors or a member of their immediate family had ever been the victim of a violent crime. We would expect judges to ask the question in case of violent crime. With respect to proposed questions on the subject of the bias due to media attention, in particular, Massachusetts courts have recognized the potential biasing effect of extensive pretrial media coverage of a case. Quoting Commonwealth v. Tulin, where pretrial publicity renders the risk of juror bias particularly acute or especially significant, both this court and the United States Supreme Court have emphasized the need for an adequate voir dire. Ms. Reed's case has been highly publicized both in Massachusetts and nationally. Since this criminal case began internationally, newspapers and news networks, including the Boston Globe, Boston 25 News, and the New York Times, Fox, NBC, CBS, and the Washington Post, to name a few, have been covering Ms. Reed's criminal case, some publishing about the case repeatedly over the course of months. Given the significant media coverage of this case and the resulting likelihood that many potential jurors will have learned information about the case through the news, it will be particularly difficult to impanel an unbiased jury for Ms. Reed's second trial. As such, allowing defense counsel to question jurors on the subject of media attention the case has garnered is necessary to ensure the impartiality that Ms. Reed is constitutionally entitled to. Questions on the remaining proposed subject of whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials should be allowed as inquiries into the prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed. Rule 63C3 of the Rules of the Superior Court. Rule 63C thus affirmatively counsels that each of defense counsel's proposed voir dire subjects should be allowed. Ensuring Ms. Reed's constitutional right to an impartial jury requires allowing inquiry into the proposed subjects. Allowing defense counsel, I don't know. I was just thinking about that. How are they going to get a jury for this trial? Who in Massachusetts? I mean, Massachusetts is a teeny tiny state. Who has not heard of this trial? Who? In all of Massachusetts, who has not heard of this trial? I mean, before the first trial, sure. But now? How are they going to get a jury? Why hasn't any of them asked for change of venue? Nobody's asked for change of venue. I'm so scared for her. And the ARCA guys are allowed to testify, but aren't allowed to testify that his injuries weren't caused by a car? What's the point of them testifying? Yeah, that would have been smart. It would have been smart. It would have been very smart. Very smart. Ensuring Ms. Reed's constitutional right to an impartial jury requires allowing inquiry into the proposed subjects. Allowing defense counsel to inquire. Okay, this is getting boring. Judy, is the one about the ARCA? Defendant's motion to seal defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Now comes the defendant, respectfully moves seal defendant's motion in limine to exclude irrelevant, admissible, and prejudicial evidence regarding alleged harassment and or intimidation of witness. Good cause exists for the sealing of this motion. Where is that motion? That's 568. 56. Oh. That one didn't load. Oh, why not? Okay, that must have been. All right, 567 didn't load, Judy. That must have been the motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment or intimidation of witnesses. Does that have to do with Turtle Boy? Hang on, let me see. Wonder why that one didn't load. $567. Huh, that one won't load. I don't know what's wrong with it. Okay. That one's a nothing burger. That's another David. Ooh, this is a good one. I know. I know. And I was talking about that earlier. Not only because I didn't understand, and I texted Judy back, and because Judy sent me the document, and I texted her back. I was like, for what? Why? I was like, why Turtle Boy? What is he going to say that's going to help the Commonwealth? What? And then Judy said, they're doing that to keep him out of the courtroom. And I was like, well, that's just dirty. And so, but I was telling Travis about it. We were eating dinner last night. I was like, well, he's still going to watch it on YouTube. And then I was like, oh, crap. No, he can't. He can't even watch it. He can't report on it. He can't live stream it. He can't do anything. He's going to be in the dark. He's going to go crazy. His head is going to explode if he can't watch this trial. I was like, Mark Betterow better button up because we're going back to court if that happens. It's not one of her charges. It's not. It's Turtle Boy's charge. Just because they think she's doing it with him, she's not. He's doing that all on his own. And I don't even think he's doing it. I think they see him out in public and he won't back down, is what it is. They might say something to him and then he doesn't back down. But I think a lot of times he does go places where he knows that he might see them. I think he does do that on purpose. Well, Turtle Boy, they tried to keep him out last time, and he was allowed to be there except when the witnesses that he supposedly intimidated were on the stand. So he was there for most of it, but not every single minute of it. But then the parts he wasn't in the courtroom for, he can watch on YouTube. But if he's on the witness list this time, he can't even watch it, which is terrible. That's just playing dirty. And we've seen Brennan play dirty already. And he's good at it, which is disgusting. Oh yeah, they won't call Turtle Boy. They don't need to call. I mean, he has nothing that will help the Commonwealth. Absolutely nothing. And he doesn't know anything that would even help the defense. I mean, he has theories and stuff. He's on the free Karen Reed side, but he doesn't know anything. Not that I know of that he knows anything for sure. But yeah, they don't have to call anybody on their witness list. He just put him on there to get him to so he can't watch it. It's just nasty. I doubt he calls him. Now my belief is he's just doing it so he can't watch the trial. Just a dirty trick. Defendant's motion in limine to exclude serum plasma ethanol concentration, blood ethanol concentration, conversion, and corresponding retrograde extrapolation analysis. And I don't think Bev is going to grant this, but let me tell you why it should be before I even read it. When she left 34 Fairview that night, She could have gone home and had more to drink. We don't know when she stopped drinking. No idea. So let's say she did hit him. I don't believe she did, but let's say she did. Let's say she went home and drank some more. Her blood alcohol that they took how many hours later in the morning does not correspond with what it was that time at night. Whether she hit him or not, it doesn't correspond with what it was at that time. So it's irrelevant. If they had got her right then at the time it happened and done the blood draw then, it would be relevant. But the fact that they took it hours and hours and hours and hours later, especially when she could have gone back home and had more to drink, makes it completely and totally irrelevant and should not even be mentioned in the trial. They should just say, we didn't get her blood alcohol content. That's what they should just say. We didn't get it. And the fact that they're trying to do that stupid conversion and they're not even sure that they've got the correct blood alcohol content is another reason why they shouldn't be using it in the trial. They're not even sure if they have it correct. So that's my opinion. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude evidence of a serum plasma ethanol concentration test performed by Good Samaritan Hospital at 9:08 a.m. on January 29, 2022. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police, as well as a corresponding retrograde extrapolation analysis. As grounds for this motion, Ms. Reed states that, as acknowledged by MSP forensic scientist Nicholas C. Roberts in his report, the ethanol result used in the reports was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore the reports do not fall under the laboratory scope of accreditation. See Exhibit A, May 4, 2022 Serum Plasma Conversion Report. See also Exhibit B, June 6, 2022 Retrograde Extrapolation Report. Since the Commonwealth cannot establish that the blood test result administered by Good Samaritan Medical Center is reliable for the purposes of a criminal prosecution, the serum plasma ethanol concentration result and the corresponding blood ethanol conversion and retrograde extrapolation, which derive the results from the initial result, should be excluded as unreliable and not the product of reliable principle and methods. Factual background. On January 29, 2022, around 7:26 a.m., Miss Reed was admitted to Good Samaritan Medical Center as a result of the acute grief reaction she experienced after learning that her then boyfriend, Officer John O'Keefe, had passed away. In addition to evaluating her, the hospital performed blood work and urine drug tests, which included tests for the presence of drugs and alcohol. Miss Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Miss Reed's blood of 93 milligrams per deciliter. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Miss Reed's blood, as would be the normal course in a prosecution involving any aggravated form of operating under the influence, Massachusetts State Police performed a conversion of the reported 93 milligrams per deciliter result to a blood ethanol concentration ranging from 0.078 to 0.083 based on three different conversion factors on May 4th, 2022. Using that conversion, Mr. Roberts then conducted a retrograde extrapolation on June 6, 2022. In both reports, Mr. Roberts explicitly notes that the serum plasma ethanol concentration obtained from Good Samaritan Medical Center was not performed at the Massachusetts State Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. After the first trial on September 17, 2024, the Toxicology Unit Administrative Manual updated conversion factors used by the Massachusetts State Police Crime Lab to align with ANSIASB Best Practice Recommendations 122 First Edition 2024 document per a new report dated October 10, 2024, authored by forensic scientist Hannah Knowles. The new serum plasma ethanol concentration estimated by the Massachusetts State Police Crime Lab is now between 0.078 and 0.082. Exhibit C, October 10, 2024, report by Hannah Knowles. Moreover, in Knowles' report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45 a.m., time of the alleged incident, in an attempt to account for the uncertainties associated with the drinking history of the subject prior to the time interval. Her calculations determined that Miss Reed's BAC could have been between 1.4 and 0.28 at 0045 hours on 1/29/22. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, 0045 hours, indicating that the subject had consumed no ethanol 0.5 to 1.5 hours prior to the time interval. Argument: because both the initial serum plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, including testing procedures and type of testing, the blood test results should be excluded. Retrograde extrapolation is a mathematical calculation used to estimate a person's blood alcohol level at a particular point in time by working backward from the time the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. The SJC has held that, generally speaking, retrograde extrapolation analysis meets the Daubert-Lanigan standard for admissibility. Breathalyzer test results are generally admissible without the need for retrograde extrapolation, without the need for expert testimony when taken within a reasonable time, defined by the SJC as 3 hours after operation of a vehicle. Colturi lays out a narrow exception in which expert testimony is required where the Commonwealth is proceeding under an imperitability theory, as opposed to a per se theory, and a test is administered outside of a 3-hour window, necessitating retrograde extrapolation. Expert testimony is required. Just last year, the Supreme Judicial Court addressed the issue of a defendant's consent to a blood test in a prosecution for simple and aggravated forms of OUI in companion cases. Skip those. The court held that the consent requirement only applies in prosecutions for simple OUI, rather than to any of the aggravated forms of OUI. Accordingly, whether Miss Reed consented to the alcohol blood test or not is not an issue here. What is at issue, however, is that the parties lack essential information about how Good Samaritan Medical Center drew and tested Miss Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test the defendant's blood through a certified analyst, in accordance with the provisions of 501. While these requirements pertain only to analysis working for the state police and not to hospital personnel, they are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. The Massachusetts State Police utilizes gas chromatography testing rather than enzymatic immunoassay testing, which presumably was used by the hospital here. In the medical records provided under the chemistry section, there is an annotation regarding the drug testing which states, "Bye, Michael. This report is intended for use in clinical monitoring and management of patients. It is not intended for use in employment-related drug testing or court-related proceedings." Ooh! Samples are not routinely tested for adulteration and are assumed to be within the normal physiological pH range of 5 to 8. Regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test result was obtained, through what procedure, by whom, and what manner or testing was used. Yeah, that's getting too sciencey. But yeah, that was another thing I didn't like about the trial, the way they did the blood test, because that was what? Brennan has lost it. Brennan has lost it. Did he ever have it to begin with? This man, oh my God. Why? Commonwealth's motion in limine to preclude reference to and redact the manner of death contained on the victim's death certificate. Are you kidding me? The Commonwealth moves in limine in accord with settled practice that the death certificate be redacted for the means and manner of death. We have stated that with respect to the admission of death certificates, the better practice is to redact the manner of death, such as the words homicide, suicide, or accident. General laws provides that nothing contained in the record of a death which has reference to the question of liability for causing the death shall be admissible in evidence. In a criminal trial, excluding the death from the death certificate the words homicide, suicide, accident, or in this case undetermined, is the better, safer course. Where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is dead, the question of liability is left solely to the trial jury. For the above reasons, the Commonwealth, in this case, the means and manner of death on the death certificate is undetermined. Yeah, because it's undetermined. Hey, Haley. Yeah. 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 What? Exactly. What? Yeah. What? I'm going to cry. This poor lady. Oh my God. So they don't want anyone to know that his death was determined undetermined. That his cause of death is undetermined, or manner of death is undetermined. His manner of death is undetermined. He wants that redacted. Oh God, I just can't anymore. I have no words either. I just Oh, come on. I know there's got to be more. Where did they go? Judy, didn't you say? Didn't you say you sent me some more? I hope you guys can't hear that. My husband's playing with his RC car. Okay, so that stupid dog bite expert that the Commonwealth asked for, that this, if you didn't see, I did not, I don't know if Judy sent them to me or not. Um, because I'm really bad about checking my email. I've gotten better since Judy's been sending me stuff in my email, but I'm still really bad about it. So, I don't think she may have sent them, but I didn't read them. Anyways, if you want to watch, I think I think Peter did them in two separate videos. He did the video where Judge Bev allowed why can't I remember her name? Dr. Russell, where she allowed Dr. Russell, and it was like 2 or 3 pages long, and she was like throwing shade about stuff, about reasons why her testimony or opinion or whatever was flawed, but it was for the jury to decide. And then Peter did another video about Dr. Crosby and how she allowed him, but it was like 1 page long. It was like one paragraph about how he's okay. And that was a video where Peter finally admitted that yes, Bev was biased towards the Commonwealth. Um, so this is the defendant's motion to reconsider to not allow this guy. And I've not read this yet. Now comes the defendant, Karen Reed, and respectfully request that this court, we didn't call her honorable this time. Request that this court reconsider its March 6, 2025 court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, MS, PhD, Dr. Crosby. And after such reconsideration, defendant requests that the court exclude the entirety of the proffered testimony of Dr. Crosby. In the alternative, and at a minimum, defendant requests an evidentiary hearing to determine whether the Commonwealth can meet its burden to satisfy the requirements of Daubert-Lanigan as regards Dr. Crosby. Remember, Dr. Russell, they did a 2-day Daubert hearing for her. Brennan asked for Crosby, and it's like, okay. In the alternative, and at a minimum, defendant requests an evidentiary. Oh, I read that part. Sorry. The defense could complete its questioning of Dr. Crosby in approximately 1/2 day of any hearing. The court's March 6 order, in denying defendant's motion to exclude the proffered testimony of Dr. Crosby, The court stated in its March 6 order that the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. The court did not provide any record citation or other record evidence for how the Commonwealth had met its burden to satisfy the 5 foundational requirements, including prominently the methods are reliable requirement. Nor did the court address the alternative request of the defendant that a Daubert-Lanigan hearing be held should the court not exclude Dr. Crosby outright on the papers alone. The March 6 order contrasts with the court-ordered 2-day evidentiary hearing of Dr. Marie Russell, a medical doctor with approximately 30 years' experience as an emergency medicine physician and forensic pathologist. Dr. Russell co-authored peer-reviewed books on dog-inflicted wounds on humans and submitted an 11-page report before the hearing in which she documented her pattern recognition methodology with robust citations to peer-reviewed studies and articles that appeared in 27 footnotes throughout her report. The instant motion for reconsideration. The defendant does not waive any and reserves all of the basis for exclusion of Dr. Crosby as stated in her original exclusion motion. Yet, for efficiency, in this reconsideration motion, the defendant focuses on just factor 4 set forth in Polk, namely that the theory underlying the opinion is reliable. This factor is also known in the Daubert-Lanigan parlance as the methodology prong. A failure of any one of the 5 foundational factors set forth in Polk compels exclusion of the proffered testimony at issue. The Commonwealth's opposition to the defendant's exclusion motion. The Commonwealth had 4 opportunities to show that it can meet the Daubert-Lanigan methodology prong. Its written opposition dated February 17, 2025, the supplemental report of Dr. Crosby dated February 19, 2025, in which he discussed the mold aspect of his unsupported mold measurement methodology, but failed to account for the absence of any requisite overlay in his methodology, oral argument on the exclusion motion on March 4, 2025, and the list of cases in which Dr. Crosby has testified in court, which was submitted to the court on March 6, 2025. In each of the opportunities, the Commonwealth failed to even attempt to show that the purported mold measurement methodology employed by Dr. Crosby in opining on whether the wounds to the right arm of the decedent was caused by a dog bite or dog attack is generally accepted in the relevant medical or scientific community, or that his methodology meets the apt Daubert-Lanigan factors. Oh, okay, I have that one. Notably, Dr. Crosby has never attempted to make such a showing either. His report is completely bereft of even a mention of satisfaction of general acceptance of his mold measurement methodology or satisfaction of the Daubert-Lanigan factors, let alone a showing of meeting them. And he has never submitted an affidavit to support anything about himself, including his qualifications or documentation of any kind of how his purported methodology is generally accepted or otherwise reliable, with citations to medical or scientific literature. The February 17, 2025 affidavit submitted by Mr. Brennan is likewise of no weight in the inquiry, as he lacks first-hand knowledge or the requisite expertise in the subject matter of the dispute. But even in his affidavit, Mr. Brennan mentions nothing but satisfaction of the common acceptance precept or the Daubert-Lanigan factors. Tellingly, Mr. Brennan merely states in paragraph 7 in a bald conclusion that Dr. Crosby has engaged in substantial methodology. Substantial does not begin to satisfy the requirement that the mold measurement methodology of Dr. Crosby is purported by evidence of common acceptance in the relevant medical or scientific community or satisfaction of relevant Daubert-Lanigan factors. Likewise, in its written opposition, the Commonwealth stated that Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm, but wholly failed to state any source for such recognition. There is none. As a result, the Commonwealth has provided the court with no basis on which to conclude that the mold measurement methodology of Dr. Crosby is reliable, the prerequisite for satisfying the fourth factor of the POLC, the methodology prong of Daubert-Lanigan. The court cannot satisfy its gatekeeper function by invoking the same conclusory statements as the Commonwealth has invoked here regarding a reliable methodology. The gatekeeping function of the court under Rule 702 and its importance. Case law makes clear that the gatekeeping function of the trial court is especially significant. This is all the more so in light of the seriousness of the charges lodged by the Commonwealth here. As the Massachusetts Guide to Evidence 2024 states, Massachusetts Rule 702 is based on Federal Rules of Evidence, Section 702, while additionally maintaining the Common Acceptance Test. As a result, federal decisions interpreting FRE 702 are particularly instructive. The gatekeeping function of the trial judge under Daubert-Lanigan and Rule 702 precepts itself of paramount importance. Under Daubert-Lanigan, the motion judge, in her role as gatekeeper, has a significant function to carry out, i.e., deciding on the admissibility of a scientific expert's opinion. Quoting Lanigan, the reason for this importance was recently underscored as follows: because Rule 702 grants experts wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation. Expert evidence can be both powerful and quite misleading. As such, the importance of the gatekeeping function cannot be overstated. A judge's findings must apply the correct legal standard to the facts of the case and must be supported by an examination of the record. The gatekeeping inquiry must be tied to the particular facts. The Polk-Daubert-Lanigan analysis is no different, whereas here the witness in question is stipulated to be a rebuttal witness. The facts and law in Hilsinger Co. v. Clean Concepts are quite similar to the instant case and thus compel the same result. In Clean Concepts, the court stated as follows: in response to a defendant's proffer of an expert witness, the defendant has not directed the court to any evidence demonstrating that Sauer's methods for determining boring. But asking her to be a gatekeeper. Let's read the conclusion. Under Daubert-Lanigan and Commonwealth v. Polk, respectfully, the court is duty-bound to fully exercise its important gatekeeper function by examining the record and making what can only be one finding: the failure of a reliable methodology by, and thus the exclusion of, Dr. Crosby on the papers alone. Any testimony by Dr. Crosby at trial about his unsupported mold measurement methodology would seriously mislead the jury into believing his methodology is based in science and is reliable. Nothing could be further from the truth. And because the issue of how the injuries to the right arm of the decedent is a key issue for both parties, his testimony with the sponsoring I don't know what that word means, imprimatur of the Commonwealth would be extremely prejudicial to the defendant. In the alternative, and at a minimum, an evidentiary hearing on Dr. Crosby is compelled. Okay, let me try to explain to you why this guy's mold, dog teeth mold, is pseudoscience. Your skin is elastic. This is a dog bite. Can you tell by looking at it that it's a dog bite? No, you cannot. And the main reason you can't is because I had surgery on it, because they had to open up the bite further to go in there and clean it out. But when Spike bit me, because he was trying to bite my chihuahua, and in his case, the reason why it doesn't look like a dog bite is because I had surgery on it. But in his case, I got in between him and the Chihuahua. And I had my hand like this to open his jaw. He let go of the Chihuahua. And then as I was bringing my hand back down to, like, to remove it, because I thought, oh, I got him separated, it's over, Spike lunged again and he bit my hand. When he realized that he bit my hand, he opened right back up. I didn't pull away or anything. He just opened back up. So I had a perfect bite mark in my hand. You could have done a mold of Spike's teeth and matched it. If a German Shepherd is biting your arm, are you going to sit there? Now, if Spike had locked on and not let go, I would have been pulling away. That would not have left little tiny holes that you could have matched with a mold. The skin would have stretched. You would have had a hole with a scrape or a scratch or long. Your skin is elastic. It's not going to make, if you're pulling, you're not going to have a teeny tiny hole there that you can take a mold and then match the hole. It's not going to happen. John O'Keefe's arm has long, and they keep calling them abrasions. They're not abrasions, they're lacerations. And then that one guy, he testified in the Murdaugh trial about something too. He's way off base because he's saying that they're not like this. They're continuations like that. Like he got his arm trapped under the car or something, and they're like this. No. The dog bit him and he jerked away, and they're long, either teeth and claws or just teeth, where the dog grabbed and he jerked and they pulled and scraped. You're not gonna match up a mold to that. That's not gonna work. So I don't know what in the heck they think they're gonna do with that mold. And number one, how many years later? 3? Is it the same dog? We don't know. Has the dog the same dentition that they had 3 years ago? We don't know. Dogs' teeth change just like people's teeth changed. Could have broken a tooth, lost a tooth. We don't know. The Chihuahua that I had like, because I got him when he was 10. By the time I got him, the poor thing only had like 4 teeth. Dogs lose teeth just like people do. How do we know that mold has the same exact dentition that it had at the time that John O'Keefe got bit by that dog? That mold is not going to prove a damn thing. So it's going to be useless. Absolutely useless. Not only that, you have to sedate a dog to get a mold of their teeth. I don't know. I'm not a vet. I'm a nurse. I deal with people. And I don't deal with teeth anyway. But what happens to a dog's jaw if you sedate them? Does that change anything? I don't know. I'm not a vet, so I don't know. It could. I don't know. I think that's pseudoscience. I don't think you can take a mold of a dog's mouth and match it up and say, oh yeah, this is a dog that bit me. I don't think that's possible. I just don't. I think that guy is useless. Of course, Right. Right. How do we even know it's Chloe? How do we even know it's the same dog? Because all through the first trial, it was like nobody knew where Chloe was. Some of the people got on the stand and said, "Oh, we know where Chloe is." Well, then how come we didn't have Chloe? How come nobody produced Chloe so we could check the DNA? Oh, well, there was no dog DNA on him. Well, they didn't swab the wounds. Well, why didn't they swab the wounds? Everything is fishy about this case. Everything. And people that are like, oh, well, you're just so biased. Well, because I watched the trial. And like, I knew nothing about this case. Nothing. I knew that she had been accused of killing her boyfriend by backing into him with a car. That's all I knew. And I watched the trial. I love that episode. I love that episode. Well, like I said, when Spike bit me, because he's my dog, he didn't mean to bite me. He was trying to bite. It was like as soon as he bit me, he knew he was in trouble. He was like, crap, I wasn't supposed to bite you. You're my mom. And like, he bit and immediately released. And I could see like his teeth. It was like a perfect, like I didn't even have time to pull my hand back. He was just like biting and back. Like he knew. And so now it looks weird because I got so infected because that was right after chemo and I was immune compromised and it got so infected so fast that they had to make 2 incisions and go in. I had 2 surgeries that I'd go in there and clean it. It kind of looks like a butterfly now. I was thinking about getting, see how it's got like, it looks like butterfly wings. I was actually thinking about getting a butterfly tattoo there, but I heard that tattoos hurt really bad over scar tissue, so I just changed my mind. But but yeah, but right after the bite, it was a perfect mark. I mean, like that one you could have molded and done it. It would have been perfect. But skin is elastic, and it doesn't. Human skin does not. You can't match it up like that. It doesn't work that way. And like I said, who knows? That dog could have lost a tooth or broken off a tooth or whatever. And then when it's in a fight like that, there's going to be overlap. You know, that dog didn't bite him just one, like here and then here and then here. There's overlap. His arm was a mess. There's overlap. And and like I keep saying, no injuries below. None. And in 17 years as a nurse, I've never seen a car accident, pedestrian or passenger, that there's no injuries on the lower extremities. Never. Never. I don't care what kind of a motor vehicle, tractor. I've seen tractor accidents too. I live out in the country. There's always injuries to the lower extremities. Always. And his legs were perfect. That man was not hit by a car. Absolutely not hit by a car. And I've got to find, Judy, do you know if you sent me the ARCA one, where she said that they could testify, but they can't testify that he was not by a car? Like, that doesn't even make sense. Because if they can't testify, that he wasn't hit by a car, what's the point? Why is this not working? Oh no, that's the no, that's cancel. That's the witness list. Okay, well, I'm trying to see. I know there's more. I know you sent me more than that. The problem is, I tried to be organized, but I've got so many different. What? Why? That's a PDF file. Why isn't it opening right? Oh. Oh well. I don't know. Okay. Well, I guess we're done. There's a couple more, but I mean, there's probably more than a couple more. I don't know why I can't. I thought I had everything because I have two folders. I have a Karen Reed folder and a new Karen Reed doc folder. Let me see. Maybe I put them in the Karen Reed folder and not the new Karen Reed folder. No, those are all old ones we've already talked about. Okay, well, we went through a lot. We've been doing this for 2.5 hours. So, nothing that makes me feel any better. I cannot believe that Hank Brennan wants undetermined redacted, or that he put Turtle Boy on the witness list. And I'm sure that the defense team has seen the witness list. But they're probably not going to do anything though, because they're going to pick their battles at this point, and that's probably not a battle that they need to worry about. But I'm sure that Mark Betterow is going to do something about it though, because that's not That's not cool. He's a journalist. I mean, he's a YouTuber, but he's a journalist. I mean, we're in a new era. I don't consider myself a journalist. This is my hobby, but he does. And I assume he makes a living doing this. So this is his livelihood. So they can't do that. Oh, he did. See, I don't watch him. I have mixed feelings about Turtle Boy. I think his heart's in the right place, but I'm not 100% on board with the way he does things. Um, the first thing of his I watched was a video that he made where he tried to reenact driving backwards at 34 miles an hour to see if it was possible. And he couldn't even get his Lexus that fast. And that was the very first thing of his that I ever watched. And the more I watched him, the more I thought, because like he would be places where they were like public places that he had a right to be at, which I admit, yes, he had a right to be there, but maybe see, I'm a non-confrontational type person. If if I know I'm somewhere, like I'm not going to leave if I have a right to be somewhere, but if there's somebody there that I know I'm going to have a problem with, I'm not going to go up close around them and act, to like instigate a thing. I'm going to try to stay small. But that's just the way I am. That's a good, yeah, extra. There you go. Extra. That's a good word for it. Like when he was in Canton, he went to Canton to do an experiment. Something he was experimenting, I don't know, something to do with a trial with the case. And he went to, what's the name of it? Is it CF McCarthy's or something like that? The for not the waterfall, but the other bar they went to, which is right beside Chris Albert's pizza place. And was it Julie Nagel that was there? It was somebody that was there at the house that night. And by the time Turtle Boy left, they were all at the sidewalk waiting for him. And no, he didn't do anything wrong. But still, if I had been him, I would not have gone anywhere near Canton. Just because I know I would have run into them. Because Canton's a small town. And especially you're going to go to the bar that is right next door to Chris Albert's pizza place. Yeah, you're going to see Colin Albert and Chris Albert. That's a given. So, no, I wouldn't have gone there. But did he have a right to go there? Sure, he did. Did they have the right to mess with him when he came out? No, they didn't. Did they get in trouble with the cops because they did that? Yes. So it's almost like he did that on purpose because he knew something would happen. He may not have. Let's give him the benefit of the doubt, but still, appearances. So that's I just have mixed feelings. That's all. I do agree with him that Karen Reed didn't do anything wrong, and I feel so bad for her because this whole thing is a mess. I remember um back when Legal Bites was explaining this case to Natalie Lawyer Chick, who is a defense attorney, and she was showing her the part where Karen Reed backed into John's vehicle and cracked her taillight. And Natalie Lawyer Chick said, well, that's it. That's it. Case closed. She's innocent. That's it. She goes, that would be the focal point of my case right there. I'd get her off. That's it. She's innocent. It was so funny because she was like, there's your smoking gun right there. That's when she busted her taillight. It was so funny, and Alita was telling her all the crap they were doing to her and everything, and she was like, "Oh no, 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 no." So to people with a brain, it's super logical that this woman didn't do what they're saying she did. So I don't understand how this is happening. I really don't understand. I feel so sorry for this woman, and it's so sad, and it's scary because if it can happen to her, it can happen to anybody. Assault on somebody else? That I, that one woman is who she's somebody's sister that's involved in the case that grabbed his phone and threw it in the street. I can't remember her name. Is that dang, I keep burping. I'm sorry, y'all. Is that who you're talking about, Judy? I can't remember her name. But somebody called her and told her Turtle Boy was there. There's pending harassment and assault on somebody not on Turtle Boy. Jill Daniels, that's it. So did she got in trouble with the cops for that, right? See, this is why Recovery Addict doesn't want to cover this anymore because of all the out of the courtroom drama. But I think it's all the more reason why we need to bring this to light because all of this stuff that's happening is illegal and it needs to stop. It's ridiculous. But wasn't there something else going on with Jill Daniels? Wasn't there something else? I type her name in and all I get is Karen Reed stuff. No, I typed in Jill Daniels and Julie Albert came up. Wait, She's Julie Alberts. It says Jill Daniels and Julie Alberts' dad was hit by an Amtrak in 2008 and died in 2011. Oh, he worked at the courthouse. Bev's father, brother, and she all worked in the same courthouse. There's the Bev McAlbert connection. Her dad was a prosecutor as well as a public defense lawyer. Bev's brother represented Chris Albert Sr. for his vehicular homicide hit and run charges. And he only served 6 months for the killing. And he was drunk. Good God. Well, small town. That's the nature of a small town. Everybody's related to everybody else. Come on, StreamYard. Don't start. I found Turtle Boy's website with video from that day at Canton, but StreamYard's being stupid and won't let me play it. So yeah, so Jill Daniels, Julie Albert's sister, caught assaulting Turtle Boy on his own live feed. It doesn't want to load for some reason. I don't know why. Come on, StreamYard. It's an article. Why are you being stupid? It has an embedded video in it. Come on. Work. don't need the video part. I just want to see the article. Yay. Well, two people have been charged with assault after a heated confrontation involving the blogger known as Turtle Boy outside a bar in Canton on Sunday. This was back in June. Police were called to break up the fight outside C.F. McCarthy's and D&E Pizza. Canton police confirmed that Jill Daniels and James Ferris have been charged with assault and battery on the blogger Aiden Kearney. Daniels allegedly has ties to the Albert family and is close friends with Trooper Michael Proctor's sister. This comes as tensions are elevated over the Karen Reed trial, who is charged with second-degree murder, accused of striking her police officer boyfriend John O'Keefe with her SUV in January 2022. Carney has covered Reed's case before, advocating on her behalf, and is now facing legal troubles of his own as he is accused of intimidating and harassing witnesses related to the case. That's it?
Canton police confirmed that Jillian Daniels and James Ferris have been charged with assault and is apparently close friends with.
Well, that was riveting. That was great. So informative. He apologized. He did a public apology at a board meeting, whatever they're called. Um, but I don't think he should still be on the board. I'd be wanting him to step down because that doesn't look good at all. Okay, guys. So that's a little bit of a catch up to what we're gonna see Tuesday and Wednesday in the hearings, in the final hearings before the trial. And I'm getting more and more and more nervous for this poor lady because she's getting railroaded. I thought the second trial was going to be better. I thought it was going to be a do-over and everybody was going to be fair and impartial the second time around. Man, was I wrong. It's worse. It is worse. All we can do is pray. Just pray. Pray hard. Pray hard. Hopefully, if she gets, maybe it'll be another hung jury and they'll just decide not to try her again. Or if she gets convicted, maybe it'll go up to the Supreme Court of the United States and they'll look at it and go, what the heck was this? And just throw it out. But then that means she'll have to be in prison for a while. And I don't want that for her. She's been through enough. Even though she's not in prison, not in jail, she's been through enough. She's lost everything. I mean, she had to sell her house. She lives with her parents. So I don't know what else to say. And like I said, I feel defeated, and it's not even me. Like, it's scary. It's scary because, yeah. Like I said, I hope, it's logical to us that she didn't do it. Why isn't it logical to accept? Didn't they say that there was that one guy that he was a trooper that said he was like security or something in charge of the jury, and he really wasn't. They were talking about it in one of the hearings, and they think that he tampered with the jury or something. I don't know. Whatever. My goat is going to be out of batteries by the end of the trial. Travis was playing with him the other day. He couldn't get him to work. He couldn't figure out. Like, the button is the stump. He still hasn't figured out what he's for. Like, why do you have a goat? Okay. All right. I'm resting tomorrow because Judy's making me now. I have to rest one day a week. Fanning. Oh, yeah, that guy. His name is Trooper Fanning. Yeah. That took me a minute. Okay, so I will see you guys Monday morning, bright and early, for more Phil Spector. So I am gonna go play my video game and fly around on my broom some more. So bye guys, love y'all. Have a good weekend. Bye.